Good morning or afternoon, ladies and gentlemen. Today in this video I'll be talking to you about patents, specifically who can apply for them and who can own them. The beauty of patents is that any person can apply for a patent. However, there is one tiny loophole to jump through, in that you have to be considered eligible under criteria provided for in Section 15 of the Patent Act 1990. Thankfully, Section 15 is relatively straightforward. It provides that a person who is attempting to be a potential grantee must be A. the inventor, B. it must be a person who would, upon grant of the patent for the invention by the entitled person, have a right to the patent assigned to them, C. derives title to the invention from either of the above, A or B, or D. is a legal representative of a deceased person who falls into one of the previous categories. Further, it must be noted that more than one person can make a joint application for a patent. This can be based on their differing contributions to the final product, or that there are tenants in common to the invention's exclusive rights. This, however, can create a somewhat murky situation when assigning or selling rights in an invention. And that brings us to the second and somewhat more complex question as to who can own a patent. Traditionally, the court has expressed an unusually simple attitude to patent ownership, and that a patent was simply presumed to have been owned by the true and first person inventor. This approach has been restricted through judicial interpretation and made slightly more complicated. The current test of ownership is now objectively assessed by levels of contribution by differing persons to any given device, substance, method or process, or generally referred to in this video as an invention. The court must be able to see that a patent would not have existed without the contribution of the party claiming ownership. If this can be successfully argued, this automatically allows a person or persons an entitlement to that invention, or at very least a partial right to its exploitation. Ownership of a patent can occur through three different ways. There can be a claim or a right to that invention by assignment, a purchase of a patent, or a claim made by the rights that derive from an employment contract. A claim of ownership for a patent made by an employer is a very complex and interesting area of the law. Basically, inventions or intellectual property created within the course of an employment contract or within the confines of a work environment tend to lead to the general assumption that property is owned by and can be claimed by the employer. This is due to the idea that all works developed during employment are done so only because of the teachings, resources and understanding provided by the employer. Due to this reasoning, cases are almost always subjectively calculated, as a whole host of factors contribute to the decision-making process. And last of all, patent ownership by assignment. Patent ownership by assignment is relatively self-explanatory. Patents at their core are considered property. The rationale of the patent regime was to inspire innovation and a greater understanding for the general community by registration of patents and the lure of financial exploitation. As such, they can be sold, leased, kept, mortgaged, or simply given away. The only restraint on this form of ownership, apart from time limitations, is geographic limitations. Currently, it is possible for multiple assignees to have the same right in a certain patent, only for a specific location. Outside this area, these rights are ineffective. Apart from this, agreements generally must be written and signed by both the assignor and the assignee. And sadly, that brings us to the end of my video on who can apply for patents and who can own patents. Thank you for watching. I look forward to seeing your feedback and have a great long weekend. Bye.